All right, what's up, y'all? Surprise! We're here because there were some, I would term them massive filings that just dropped in the Richard Allen Delphi case. And we're going to go through them with you because they're pretty interesting and they're pretty informational in terms of what they're providing with us. So say hi, Ellie.
Hi, all.
Hi. Okay, so we're going to start. There were multiple filings. We're getting the filings directly from the clerk. The first thing that we're going to go to, if I can figure out how to share this screen, will be. Let me look at this. All right. All right. I think this is it. Okay. All right. So this is the first thing that we have. This is a verified notice of continuing representation. Comes now, Attorney Bradley Rozzi for Richard Allen, in support of his verified notice for continuing representation. Right off the bat, Rousy is not out. Okay, and we had said as much. I was saying at the day of that it went down, that he was talking about wanting to file something in writing. That he didn't make an oral motion. It was my hope that he was going to continue on. And frankly, I didn't think that he was out of the case at that point because he didn't make an oral motion to withdraw. So I wasn't sure why Gull was saying that he was out. I was confused by that. Okay, so we're going to continue. I'm going to read this thing in, y'all, because it's worth listening to. So these are the facts, as Rousy states them. On November 14th, 2022, counsel entered his appearance on behalf of Richard M. Allen. Okay, that's when he first entered his appearance on behalf of Allen. Counsel is engaged in the continuous representation of the defendant, Allen, since that date and time. On October 12th, 2023, the court communicated with Prosecutor McLeland, Attorney Rousy, and Attorney Baldwin, at which time the court ordered Attorneys Rousy and Baldwin to, quote, cease work on Mr. Allen's case until the parties were set to appear in court on October 19th of 2023. The chilling effect of the court's emailed order was to essentially strip defendant Allen of his Sixth Amendment right to representation and essentially disarmed attorneys Rousy, Baldwin, and defendant Allen during the week leading up to the scheduled hearing, which was ordered by the court sua sponte.
I just have to say she was really shocked, but go on.
Yeah, she was really shocked, right? But not so much shocked. Like I'm not going to try to sit here and say that we absolutely nailed all of this,
but go on.
Right. All right. So Allison was like, "Don't go out there and say we nailed it." So paragraph 3, in October 17th, 2023, email, Attorney Rousy requested a conference to determine, quote, what we, the court, prosecutor, and defense counsel, are trying to accomplish on Thursday, especially in terms of what is expected of us while we are on the record in open court. In response, the court ordered both the defense and prosecutor to appear in chambers at 12:30 p.m. on October 19th. Brad Rozzi is putting the judge on blast right now. There is nothing that is
worse in the next motion.
Yeah, well, we'll get there, kids. We'll get there. Trust me. I'm going to continue. On October 4th, 2023, Rousy and Baldwin appeared at the Allen Courthouse in advance of the 2 p.m. hearing. This was prompted by Attorney Rousy requesting the parties communicate in advance of the scheduled hearing. Paragraph 5, Rousy and Baldwin appeared in chambers on the 19th at approximately 12:30 p.m., at which time the prosecution was present. Attorney Rousy, of the understanding that the court reporter secured an audio recording of the in-chamber conference, which took place in 2 parts. The court first concluded business as it related to several pending motions by communicating with the parties and issuing rulings on said motions. Paragraph 7, the court then read a prepared statement, Allison.
Yes.
To attorneys Rousy and Baldwin, identifying various issues throughout the case, through which attorneys Rousy and Baldwin exercised gross negligence in carrying out their responsibilities as counsel for defendant Allen. The court then suggested that attorney Rozzi and Baldwin engage in a discussion outside of chambers regarding the allegations. Attorneys Rozzi and Baldwin asked for clarification, at which time the court communicated to attorneys Rozzi and Baldwin that there were two distinct options. Two distinct options. Thank you. Either voluntarily withdraw their appearances and exit the courthouse in advance of the hearing, or participate in the 2 p.m. hearing in the courtroom where a media camera was installed, the national media was present, and law enforcement community was seated in the jury box directly behind the defense counsel table, at which time the court would read the prepared statement into the record and then disqualify both Rozzi and Baldwin in the presence of defendant Allen, his family, and the general public.
We're frozen, Beg.
We're frozen?
On my end, so maybe not on the world's end.
Okay, I don't know. Look in the chats and see.
I'll figure it out. Yeah,
we're frozen. Hopefully, I'm not frozen, because this would be a suck day to be frozen.
I am. You're not. Go on.
Okay. After waiting approximately 1.5 hours for defendant Allen to arrive at the courthouse, attorney Rozzi and Baldwin communicated with defendant Allen regarding the stark choice. I called it a Hobson's choice last night, I believe, that the court had offered in chambers. Hobson's choice means no choice at all. Either get out or I'm going to pants you in front of the world. Man. All right. So the stark choice of the court had offered in chambers. Defendant Allen reaffirmed his desire to move forward under the representation of Rozzi and Baldwin. As of October 24th, defendant Allen objects to the court's attempts to strip him of his current counsel. Attorney Rozzi and Baldwin, attorneys Rozzi and Baldwin. There is a footnote. I missed where it was. Footnote in paragraph 8 on October 12, attorney Rozzi filed correspondence with the court. Said correspondence contained a letter dated October 11th, 2023, signed by defendant Allen, wherein defendant Allen acknowledged that he was aware of the issues regarding the crime scene photos that were stolen from attorney Baldwin's office and desired that Rozzi and Baldwin continue on with their representation of him. Okay, paragraph 9. After speaking with Mr. Allen, attorney Rozzi and attorney Baldwin then returned to chambers. This is the absolute blow by blow of what went in that courtroom, what went on in those chambers that we were talking about last night. This is it. This is like exactly what happened. And again, I'm not going to try to be that guy, but I got to be that guy. We just nailed it. It's exactly what I said happened. I mean, we've been there. We've been on this side of it where Rozzi and Baldwin have been in matters. And this is, he's laying it out there for all of us. And I respect the hell out of him for it. He's going to catch a lot of shit for this. But you know what? Good on you, Brad Rozzi. Rosie. I keep calling him Rosie. What? Are you back? Hold on. Sorry, y'all. I'm super excited, if you can't tell. I cannot see how to get you back on. Oh, add to stage. All right. There's my girl. What's up, girl? All right. So,
and it's hard to say Rossi when you're looking at it because of
because it should be like I'm Italian. It's Rosie. Rosie. Hey, Brad Rozzi, you come back into the court.
All right, come on.
I'm Italian. I can do it. After speaking with Mr. Allen, attorney Rozzi and Baldwin then returned to chambers, at which time attorney Rozzi articulated to the court that the court had engaged in an ambush of defense counsel, entirely void of due process. And attorney Rozzi would withdraw his appearance, but that said withdrawal was not a voluntary withdrawal because the court made clear that if attorney Rozzi did not agree to withdraw, the court would publicly shame him in front of the world and his client before forcing him off the case by DQing him.
Wow.
Woo-wee! All of the events in chambers occurred without any formal allegations, contemptuous behavior by attorneys Rozzi or Baldwin, without any pending pleadings requesting disqualification. This is what I was trying to say, y'all. Like, again, when I was walking out of the courtroom that day, I'm like, where is the record of them, either Nick McClelland filing a motion to DQ them or the court sua sponte on their own motion seeking to DQ them? We are not living in a crazy world. Due process of the law matters. Due process of the law is the law of the land.
All right, keep going because there's more.
Oh man, I'm pumped up, y'all. I'm pumped up. I'm sorry, but I am. All right. All of the events in chambers occurred without any formal allegations of contemptuous behavior by Rousy or Baldwin, without any pending pleadings requesting disqualification of defense counsel, and without any pending disciplinary complaints with the Indiana Supreme Court Disciplinary Commission. So when I'm telling you all to quit calling it the bar, it's not the bar, it's the disciplinary commission. They are who would discipline attorneys, suspend, disbar, fine, all that good stuff. In total, this is paragraph 11. Attorneys Rozzi and Baldwin have practiced law in the state of Indiana for more than 50 years without a single substantiated finding of disciplinary action against either. So everybody that's wanting to trash Baldwin, that kind of speaks for itself. Now, he was sloppy. Don't get me wrong. But people stole stuff out of his office. Like anybody suggesting that he was orchestrating it, that's as egregious as, yeah, I'm not going to get on that, but man, right. It's been upsetting me. At no time while in chambers did the court ever articulate to either Attorney Rozzi or Baldwin that their conduct compromised defendant Allen's defense in any way. That's kind of key, isn't it, Bay?
It's pretty key.
It's pretty key. In fact, defendant Allen himself doesn't believe this to be the case. Paragraph 13. There are no bona fide facts. Bona fide. There are no bona fide facts or circumstances wherein Attorney Rozzi engaged in gross negligence, nor was there any showing that any conduct by Attorney Rozzi resulted in negative consequences to another party, i.e. defendant Allen. In sum, Attorneys Rozzi and Baldwin did nothing to compromise Richard M. Allen's case or defense. I changed the word, I added case. Attorney Rozzi's oral acquiescence to withdraw his appearance as defendant Allen's attorney was forced, coerced, and driven only by the circumstances created by the tribunal, which delivered two terrible options: quit or be shamed in public before being DQ'd from representing Mr. Allen. Dude, can I get
yeah, we all know you nailed it.
I nailed it. Nailed it. The court's premeditated ambush of the defense placed attorneys Rozzi, Baldwin, and client Richard Allen in a most compromising position. The trial court's stated intention to read a prepared statement criticizing defense counsel created an impossible ethical bind. If counsel did not agree to withdraw in chambers, the trial court would publicly disparage their representation of the accused, framing their advocacy on his behalf as gross negligence, casting both counsel and the merits of their client's defense in a negative light. This public statement, this is such an important paragraph. This goes to the heart of it. These guys laid on the sword for their client, and now Rozzi's striking back. Man, I'm so proud of him for doing this, because this takes huge balls. Make no bones about it. This takes a massive amount of balls to, babe.
Oh yeah.
Come out and fire on the judge like this.
Yeah. It's not.
I mean, this is serious business, folks. These are serious allegations that are coming forward. This is something else. It really is. This public statement.
I mean, they're going to have repercussions with all the judges in this county.
They're going to, unless they're right.
Well, it sounds like they are, but still,
unless they're right, then they're not going to have repercussions from anybody. Because if Gull was out of hand, Gull was out of hand.
So keep going.
All right. The public statement in circumstance created by the trial court risked tainting the jury pool, harming their client's defense, undermining their professional relationship with the client, and possibly creating an actual conflict for their continued representation, which goes to Brett's question of why they hired counsel. This is why. Paragraph 16, the jury trial in this matter is set to commence on January 8th, 2024, a full 1 year and 3 months after the arrest of defendant Allen. The appointment of successor attorneys will prejudice defendant Allen by and through further delays in his case and trial. If, however, Attorney Rousy moves forward with his representation of defendant Allen, there will be no need for two newly appointed attorneys to dedicate hundreds and thousands of hours towards a mere review of the discovery, which continues to pour in as of late September. There will be no need to marshal all the discovery and return it to the prosecution. There will be no need to bring up to speed new staff members, investigators, and possibly a new set of experts to address the many complicated issues that have already been addressed by the defense. A new defense team would likely result in a shifting of the strategy and approach of Allen's current defense team, which in turn would further delay and compromise Richard Allen's defense. Finally, any successor lawyer would have the convenience of working with Attorney Rousy to become familiar with the subject matter in a much more efficient and fiscally responsible way. All these truths weigh heavy in favor of Richard Allen's choice to maintain Attorney Rousy as his counsel of record. There are no circumstances under Rule 1.16 of the Indiana Rules of Professional Conduct which warrant the withdrawal of Attorney Rozy's representation of defendant Allen. Attorney Rousy notices up this court of his intention to move forward with the representation of defendant Allen until the final disposition on this matter has been made. Signed, Brad Rozzi,
and
dated last night.
And of note is this is a verified pleading, which is sworn. He is swearing just as if he's under oath in court to the accuracy of what is contained in the factual statements within the motion. Now, while Bob's booting up the next motion, which he already has ready, I did just want to note, even though it's like in the middle, but it was a pretty big thing. Well, first, you get Angela Patrick donated. She did both things. So Angela Patrick gave $50. And she donated 5 Defense Diary subscriptions. So now we're moving to the disqualification of the judge, people.
Ooh,
that is what's happening now. They are moving to disqualify the judge. I had the rule all booted up to read to you, but this attorney, as I should have expected, put the entire rule in here, which Bob's going to now read to you anyway. But this is what's coming at you next.
So again, filed 10/25, 2023, 7:51 p.m. Brad was feverishly typing things up. Here you go, Your Honor. Here you go. I got this for you, Your Honor. All right, enough. Motion to disqualify. Comes now the accused by counsel. And note, he still considers himself to be counsel. By counsel and pursuant to Rule 2.11 of the Indiana Code of Judicial Conduct and Rules 12B and D of the Indiana Rules of Criminal Procedure, respectfully, and moves for the recusal and change of judge from Judge Francis C. Gull. Siegel. Wow. Francis Siegel.
Yeah, we get it, babe. Go on.
Pretty good. Paragraph 1. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to disqualify himself or herself when the judge's impartiality might reasonably be questioned. Such is the case in this cause of action for the reasons described below. Paragraph 2, the comments to Rule 2.11 provide additional guidance. Subsection 1 or paragraph 1, under this rule, a judge is DQ'd whenever the judge's impartiality might reasonably be questioned, regardless of whether any of the specific provisions of paragraphs A1 through 6 apply. In many jurisdictions, the terms recusal is used interchangeably with the term disqualification. Paragraph 2, a judge's obligation not to hear or decide matters in which disqualification is required applies regardless of whether a motion to DQ is filed. Paragraph 5, a judge should disclose on the record information that the judge believes the parties or their lawyers might reasonably consider relevant to a possible motion for disqualification, even if the judge believes there is no basis for the DQ. Paragraph 3, now he's going to start giving some receipts. Judge Gull has removed and concealed or allowed to be removed by the clerk of Carroll County defense pleadings from the chronological case summary in violation of the Indiana Supreme Court's administrative rules. Those pleadings include the Franks motion filed 9/18/2023, the Franks memorandum filed 9/18/2023, 3 affidavits from Warden Gallipoo, Sergeant Jones, and Sergeant Robinson. I did not realize that she pulled those from the dockets too. Those are the affidavits wherein the guards and the warden were all admitting that they were wearing Odin patches.
And I will note that, you know, he is using very harsh terms here. We know she just sealed those, whether it's right or wrong, you know, it's not quite as nefarious as he's wording it, but still, point taken.
Yeah, point taken. All right. Okay. And then in the affidavit of the leaker, Mitch Westerman, Judge Gull has not removed or hidden any of the state filings. Okay, paragraph 4, Indiana Access to Court Records Rule 2A provides in pertinent part, quote, all persons have access to court records as provided in this rule, and that certain persons have greater access to court records. The commentary to ACR Rule 2A is that, quote, all persons, including members of the general public, the media, and commercial and non-commercial entities are entitled to the same basic level of access to court records, end quote. And ACR Rule 4 provides that a court record is accessible to the public except as provided in Rule 5. He then goes on. ACR Rule 5A provides that certain entire cases shall be excluded from public access without notice of exclusion. But this entire case has not been declared confidential by statute or rule and meets none of the other criteria laid out in ACR Rule 5A. ACR Rule 5B provides the process. Can y'all read this? Or I'm going to blow it up a little bit more for y'all. Okay. The process, where was I? Beep, beep.
That's where you were.
I can't remember. The process for excluding individual case records. However, none of the 13 listed grounds for excluding public access to records secreted from the docket in this case apply to the above referenced documents, which have either disappeared from the CCS, which is the court system, or are inaccessible to the public, nor were the documents filed using the procedures required by ACR Rule 5B, i.e. filing on green paper or filing electronically as a confidential document, along with an ACR form identifying the specific grounds upon which the exclusion is based. He's basically saying, if you're going to disappear the documents, there has to be a reason why. And he's claiming that there isn't, which I agree with. I mean, but for you, like sending emails to the clerk the second we find out that something, like we don't have 90% of this stuff. Like, thankfully, you got us the memo before Gull sealed it 2 hours after it was filed.
And I know you're mid-sentence here, but I just want to note that this first paragraph that he's focusing on would not typically be the basis for something as extreme as disqualifying a judge. You know, but I'm sure it's building up. So, and babe, did you tweet that we're talking about this, like that it's the disqualification of the judge?
I talked about 2 giant filings.
Well,
I mean, I'm live. If
you're live. Go
figure it out.
Move on.
I can figure it out. This Trump's tweeting. Okay. All right. By secreting pleadings from the docket without following the access to court records rules, Judge Gull has allowed violations of public access because those acts have only shielded documents from the defendant. These actions clearly demonstrate a lack of impartiality and fairness in violation of Judicial Rule 1.1, compliance with the law. And he has a footnote that I'll read, which is a judge shall comply with the law. Hey, that makes sense, including the Code of Judicial Conduct. All right. And also Rule 2.2, impartiality and fairness. Now, I mean, there's something to be said. Yes, he is using harsh language. Yes, on its face, this allegation alone is probably not enough to DQ her or for her to recuse herself. I could tell you right now, there is a 0.0% chance that Gull is going to get on the bench and recuse herself because he is fired back.
Right, but under this rule, it has to go to the chief judge for the chief judge. Right.
He's taken it out of her hands. Now, we've had situations where we've filed motions in cases asking for a judge to recuse themselves. This is different. He's gone above her Because I mean, sometimes you can go into a judge and make an argument. Look, this is what we're saying. I mean, I think when we tried to have
read it, because we don't know yet if he might be asking for both.
Okay. So paragraph 5, on October 12th, 2023, Judge Gull instructed appointing counsel to, quote, cease work on Mr. Allen's case, which interfered with the attorney-client relationship and prejudiced the accused by denying him the timely, effective representation guaranteed by the state and federal constitutions. Paragraph 6, on October 19th, 2023, Judge Gull conducted critical stage proceedings in chambers outside of the presence of the accused, even though she had ordered him transported and he was available. Now, this is what we were talking about. Like you and I, in any case that we've ever withdrawn, I have never had it where it's not on the record with our defendant standing by, who's been properly noticed up, and him being put, or him or her being put on the record. What is your opinion of your attorney wanting to withdraw from the matter? We now know why that did not happen. Because he certainly, Allen would not have said, I'm okay with it.
We took issue with that. Made no sense.
Right.
Then.
Exactly. She then did the same after placing his attorneys. Oh, wait, I'm sorry. Even though he was transported, she then did the same after placing his attorneys in an ethical dilemma. And again, creating a public record outside of the presence of the accused. This ignored clear precedent. I wish he would have cited the case. On October 19th, 2023, Judge Gull ambushed appointed counsel with a planned Hobson. Do you think Brad Rozzi watched our live?
No, babe, move on.
Okay. You sure?
I'm pretty sure.
You sure? Okay. Judge Gull ambushed appointed counsel with a planned Hobson's choice designed to coerce withdrawals. The choice presented was to suffer a public shaming and be removed from the case or to voluntarily withdraw. Despite defense counsel requesting clarification as to the topics and or motions to be addressed at the October 19th, 2023 hearing, she gave defense counsel no notice of her plan to force withdrawals or remove them, thus denying counsel the opportunity to adequately refute her accusations. Paragraph 8, and I don't know, did I miss the second footnote? Okay, it's basically just a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Paragraph 8, the same day that Judge Gull had prepared a statement that she threatened to read to the public, alleging defense counsel was grossly negligent in the representation of defendant Allen, Judge Gull's complaint was more about not having control over counsel, rather than any legitimate concerns that counsel had engaged in conduct that compromised Richard Allen's defense. A general summary of Judge Gull's complaints are as follows. This is in chronological order, okay? And Allie, like, I know you weren't digging into this thing like from the get, like I have been always, but once they got Allen under arrest. Paragraph A is a press release, generic in substance, was issued by the defense in November of 2022. Do you remember that document?
Sorry, I was trying to look at the rule for
okay, I'll keep reading.
Forcing the judge to be disqualified. The rule he's quoted so far deals with the judge recusing themselves, and he might get down into it more, so keep going. Okay,
so was issued by the defense in November of 2022 before the court's gag order and only after repeated press conferences by the prosecution. So that was basically the letter that Rousy and Baldwin wrote, where they were unequivocally stating that their client was innocent, that he had, that he was at work the night that they think, like, it was basically them laying out their defense to the PCA before she gagged the case. Okay. Allen's response, the intent was only to level the playing field. This was well within the obligations of defense counsel by established guidelines. She never expressed any concerns over the multiple press conferences by the prosecution. B, 2 motions filed by the defense, one of which addressed the health and safety of defendant Allen, and the second of which addressed the immediate transfer of the accused due to the not so coincidental and undisputed facts that the individuals engaging in Norse paganistic practices may have not only murdered 2 girls, but that they were escorting defendant Allen around the prison at the same time his health was in rapid decline. That's something. Allen's response. So this is, remember, B B is what the judge said. Okay, B, remember, the judge handed them a list of things that she was going to read publicly. Al, are you paying attention?
Yes, sorry.
Forget that rule. I mean, forget it for the time being.
Gotcha.
So, did you hear that? So remember, this is what he's paraphrasing what Gull said in this statement that she was threatening to read, and then he's giving his response. So he's saying that Gull, I want to read it again, that Gull was going to say 2 motions filed by the defense, one of which addressed the health and safety of the defendant, Allen, and the second of which addressed the immediate transfer of the accused due to the not so coincidental and undisputed facts that individuals engaging in North's paganistic practices may not have only murdered 2 girls, but they were also escorting defendant Allen around the prison at the same time his health was in rapid decline.
That's not what he said, right?
Who said? What?
She's saying that that's what their motion said.
This is a paraphrase of what Gull was going to read to the public. Got it. Okay. Remember, he said that she.
Right. Yeah. I'm just saying, I didn't think that if that's what she said, I didn't think that that the defense was insinuating.
That's irrelevant.
Right.
He's paraphrasing what she gave him in chambers and said, I'm going to read this statement in front of the world. That's all you need to remember about this. Now, he's giving the response. The court had previously ordered the accused transferred to a state prison at the request of the Carroll County Sheriff. His mental and physical health began to immediately decline. Prison guards in his area had Odinist emblems on their uniforms, which endangered their client after the Odinist connection was exposed. The defense had video of the patches, and the guards admitted they wore them. The defense had previously noted a connection between murders and Odinism. The patches have since been removed. Mr. Rozzi cited instances of abuse. Those filings were within the obligation, established guidelines imposed for effective representation. C, Mr. Baldwin had drafted an email to co-counsel, but sent it to the wrong person due to his self-populating an electronic mail.
I have to say, that's the accidental on purpose email.
Is it?
I don't know.
No, why would you say that?
I don't know. I just thought of it. I don't know. I have no idea.
What was accidentally sent to this guy, and it's this Woodhouse guy. Sleuthy and I have been digging into this. Sleuthy's really been digging into Woodhouse. So
that was actually Larry David, by the way, for anyone who didn't know, the accidental on purpose text.
Yes. I don't think this is that.
All right.
So why? So he ended up sending him, basically it was like the exhibit list breakdown. So it wasn't actually the pictures. That's what went to Woodhouse. And it was a former client of his. Got it. So I don't think that he's sending it to a former client of his that has no relation to the case. But okay, so this is Alan's response. This was an accident that happens routinely to most people. It's happened to me. I've accidentally sent emails to people that I didn't mean to. The intended recipient, attorney Brad Rozzi, and the unintended recipient share the same first 3 letters of their name or their first names. The email attached contained no substantive information, just a bare bones outline of a tiny portion of the discovery received by the defense in the case. D, the court alleged that Mr. Baldwin put improper statements in his Frank's memorandum. Oh, I like that Rosie's saying, yeah, Baldwin wrote that thing. The court alleged that Mr. Baldwin.
Wait, there was a second part of that sentence.
Where? I'm not done reading it.
Oh, sorry. Okay.
The court alleged that Mr. Baldwin put improper statements in his Frank's memo, not false or misleading statements, just improper in her opinion. Alan's response: the court has disdain for the defense for not filing it under seal, even though there was no order to do so. That memorandum was demanded by the prosecution before there could be a Frank's hearing. It is an impressive piece of legal writing and has been lauded by expert defense counsel across the nation. Wow, lauded. Yours included, my friends. I mean, you lauded and also it was a little long in the tooth with the Odin stuff, but in terms of what it did, it was I lauded it. Right, both lauded and shat upon. He forgot to add
and shat upon.
There's no question I have issues with some of it. There, you
I
know,
mean-
but it was like not issues with the content, but the issue that I think that they misplayed it.
Got it. Go on. I'm sorry.
It's okay for us to have discussion while we're reading it.
Cool.
Yeah. I mean, like you keep trying to force me to read the thing. I'm trying to talk to you.
All right.
bro.
I'm sorry.
Come
I
on.
didn't, I felt
You
like
need
I was
to
just
hear your
kind of
brilliance.
side
man.
chair chiming in over here.
Yeah, no, I love hearing. You can chime in whenever you want. Like as a matter of fact, I want you to chime in whenever you want. Okay. Okay, I forget where I was. The memorandum. Okay, the court has disdain. Blah blah blah. Did I read that entire one? It's impressive. Yes, I think I did. It again was required by applicable guidelines. That Mr. Rozzi had filed a tort claim notice to preserve the rights of his client. The court opined that this action amounted to gross negligence. Okay.
I know not what they refer. Do you?
I'm assuming that he has now filed a civil lawsuit, it sounds like to me. Can we get somebody on that? Anybody? Sleuthie, if you're in here, can you try to see if Rousy has filed a tort is a civil action? So, wow. Okay, Alan, the filing of the notice was intended to preserve the rights of a man who was shuttled off to one of the most secure detention units in the state, locked up and isolated with only a tablet, which was often dysfunctional, to communicate with the outside world. Alan had no ability to speak with his wife in private, as his phone calls were all being recorded. Alan's own attorneys were required to make advance reservations to visit him at prison. It is entirely impractical that Alan would have had the means to prepare his own tort claim notice and or secure private counsel to do so.
I was going to say, at first I thought they were complaining that he couldn't talk to his wife without being recorded as like an issue in the tort claim. But
yeah,
he
must be talking about. Yeah, I think Alan filed something on his own behalf about him being stuck in Westville.
Right. And he couldn't call his wife and say, hey, will you file this thing for me about these guys doing all this? Because he didn't want them to know he was complaining about it, type of thing.
Okay.
Got it.
All right. So Mr. Baldwin had, quote, hired a lawyer to represent him in this matter. Alan's response: this was not true. Mr. Baldwin was betrayed by a friend, and there was a subsequent related suicide. As a friend and colleague, David Hennessy suggested he needed a lawyer to speak on his behalf, and he volunteered. No fee was arranged between the two. The court also alleged undersigned had put volatile facts in the memorandum regarding possible sanctions or disqualification. The true facts in a criminal case are often volatile. There was no untruth.
Well, I'd say if you scroll up, he's kind of parsing words there, whether he paid, retained him, or he, either way, he had a lawyer represent him.
Well, I mean,
I'm just saying it's,
Well, I mean, we just had this discussion last night with appointed counsel as public defenders, and when that transitions, it doesn't matter that they weren't paid. So, I mean, I hear what you're saying. It is parsing words, but I think it's of note that they didn't pay him to represent them, that he volunteered it.
They could have left that one out.
I mean, they could have, but I think that she was addressing it. I think they're addressing point by point. Remember, she handed them a document and said, this is what I'm going to read to the public.
Right.
Okay. Which goes to Brett. Brett was shocked by the hiring of an attorney or that he brought on counsel. So, kudos to Brett on that one. Maybe maybe it's what? Why do you always have to do that?
Because I haven't read the whole thing, so I'm still dying to know.
I know, man. Well, I mean, we're getting there, girl.
You're getting there.
I'm sorry. But I digress. All right. The dissemination or quote leak of the crime scene photographs in which neither Rousy or Baldwin had knowledge or participated in. Alan's response: see affidavit of which Mitch Westerman previously filed. 9 guideline 1.1 of the Indiana Public Defenders Council Performance Guidelines for Criminal Defense Representation states that, quote, the paramount obligation of a criminal defense counsel is to provide zealous and quality representation to their clients at all stages of the criminal process. Similar obligations are recognized by the American Bar Association, the National Legal Aid and Defender Association, and the National Advisory Commission on Criminal Justice Standards and Goals, and Rule 1.1 of the IRPC. Paragraph 10, everything cited by Judge Gull is concerning was either not attributable to Attorney Rozzi or Rousy, is excellent and ethical lawyering in the best interest of the client's defense and mental and physical well-being. Paragraph 11, excuse me. Throughout the pendency of this proceeding, the defense has exposed untruths by law enforcement, withholding of exculpatory evidence by the prosecution, and discovery violations about which Judge Gull showed no concern and did nothing. The court has routinely expressed umbrage at defense counsel's representation through investigations and filings, while silently abiding the prosecution's discovery delays and false statements by them or their agents. This is shots from the bow.
Yeah.
This is like a pirate ship shooting on another ship. It's like, I mean, it's a big deal when lawyers step out and flamethrow a judge. It's a big deal. It really is.
I understand.
Like, I just need people to understand, again, love them or hate them. This took huge sack by Rousy. Huge. This guy 100% believes that his client is innocent. No one fights like this for their client if they're like, they just don't. I mean, it's twofold. He's trying to protect his reputation without question. And if anybody's going to shit on him for doing that, shame on you. This guy's practiced for a long time and hasn't had one complaint ever. And the judge is casting shade on him. I'm proud of him. Good on him. He deserves to do this. He's worked too goddamn long in his career and built too goddamn good of a reputation to have a judge shitting on him. So I'm glad that he's doing this, frankly. On October 19th, 2023, Judge Gull coerced an oral request to withdraw from Attorney Rousy. That did, is that a typo? That did not comply with Rule 3.8H, Indiana Rules of Trial Procedure, and further coerced an oral request from Attorney Baldwin to withdraw as co-counsel in the cause. 14, Judge Gull has exhibited a lack of concern about and taken no action to protect the physical and mental health of the accused, which I agree with completely. We're sitting on that pending motion for the immediate transfer, especially after she found out. And I don't care if she believes it or not about the Odin shit.
Right. He's innocent until proven guilty.
And
so
beyond that, the guys had Odin patches on. You get him out of there. It doesn't matter.
Right.
It's to me, it's outrageous that she would expose him in any way, shape, or form for exactly what you said. He is presumed innocent, Madam Judge. Throughout these proceedings, Judge Gull has exhibited a bias and prejudice against the accused and his attorneys and in favor of the prosecution. I'm going to let you all know, I'm really letting my defense freak flag fly today because it needs to be flying today. This is a day for defense attorneys. All my prosecutors, friends, and I love y'all. This is a day for us. This is a day that we're sticking our flag in the ground. I'm proud of these guys, because there's been a lot of shit cast on these guys after that memo, besmirching their character, besmirching their ability to practice law, and
their continued fight for their clients' best interests.
Right. And I'm really, really happy that this came out today. I really am. You can tell I've been on tilt for the last few days. Since I walked out of that courtroom, I've been on tilt. So Brad Rozzi, thank you for filing this today. Or last night. Throughout the entire proceedings, Judge Gull has exhibited a bias and prejudice against the accused and his attorneys and in favor of the prosecution. Flat out says it. Counsel for the defendant are appointed pauper counsel, and upon appointment, judicial control and oversight of the appointed counsel is inappropriate. The court cannot and should not dictate the process of representation or improvidently curtail the representation of counsel. It has done so without notice to the defendant or his counsel, affording them an opportunity to be heard. Hello, due process. It also has done so of its own accord. That's the sua sponte stuff, without any precipitating motion or request. No due process has been afforded. That is Gospel. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to DQ himself or herself when the judge's impartiality might reasonably be questioned. I mean, based on what we're hearing, Allie, where are you at on this thing? I might be too like pumped up right now. Like I should probably take a step back after we're done reading this and try to think if I think that it reaches what it needs to reach in terms of her not recusing herself, but being DQ'd. You know, I mean,
right. And again, I think there's a different rule on removal of a judge but let's get.
I mean, we're getting down to the end of it. So, okay. So, I'll read that again. Rule 2.11 of the Indiana Code of Judicial Conduct requires a judge to DQ him or herself when the judge's impartiality might be reasonably questioned. Such is the case in this cause of action for the reasons described below. All right. So Rule 1.2 of the Indiana Code of Judicial Conduct states that, quote, a judge shall act at all times in a manner that promotes public confidence in the independence, integrity, and impartiality of the judiciary, and shall avoid impropriety and the appearance of impropriety. Paragraph 19, as previously stated, Judge Gull strong-armed attorneys Rousy and Baldwin with that's what they're going point with a prepared statement that she intended to read into the record, and had either attorney resisted her efforts to remove them from the defense. So you know what I was wrong about was her being like, hey, give it like courteous about it. Like, hey, Brad, this is a courtesy. I'm going to give you the courtesy that I'm going to DQ you, but I'm giving you. So it was worse than that. Like I gave her the benefit of the doubt that she went in as a professional. And
I mean, either way you do that, however nicely that you say that, with the alternative being otherwise we go in front of the press and live TV and, but go on because he's all right.
Okay. Within minutes. Okay. So I'm going to read it again. As previously stated, Judge Gull strong-armed Rousy and Baldwin with a prepared statement that she intended to read into the record, had either attorney resisted her efforts to remove them from the defense. Within minutes, Judge Gull took to the bench, started the record, and informed those present and the viewing public that there existed an unexpected turn of events, with the defense team withdrawing from the case. Judge Gull further stated these circumstances were, quote, clearly outside of our control, end quote. The only clarity offered up by these statements is that they were entirely inconsistent with her actions in chambers just minutes earlier that forced the attorneys to consider withdrawal in this matter. These words run afoul of 2.1 as they demonstrate the tribunal's lack of integrity and impartiality toward the public and usurp defendant Allen's right to competent legal representation. Paragraph 20, 2.2 of the Indiana Code of Judicial Conduct requires that, quote, a judge shall uphold and apply the law and shall perform all duties of judicial office fairly and impartially. Comment 1 to the rule states that, quote, to ensure impartiality and fairness to all parties, a judge must be objective and open-minded. Paragraph 21, Rule 2.15 of the Indiana Code of Judicial Conduct states in part, paragraph B, a judge having knowledge that a lawyer has committed a violation of the rules of professional conduct that raises a substantial question regarding the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects shall inform the appropriate authority. So this is where he's firing back. This is his retort to the exact point. Okay, judge, you're saying that we violated our ethical duties with the leak. Why didn't you let the disciplinary commission know? It's required under the law. Where is your notice to them? Are you listening or are you looking at something?
I went because I noticed there's no wherefore clause. So I went back to the top to see what relief they were seeking.
All right. But you see what he did here? So basically he saved this one for close to last. like, you know, because she's making these allegations, and I've heard various people talking about like how hideous this ethical violation was by Baldwin for to allow this to happen on his watch. And I obviously have always rejected any notion that he intentionally disseminated the. I mean, talking about like a just kind of a like a really quasi slanderous comment about somebody to suggest that he would have purposefully let this stuff out. I don't know, man. That's a lot. It's a big leap to make, and it's a scary one when you're dealing with somebody's reputation in practice. So basically, what he's saying is the judge didn't make the complaint to the disciplinary commission. If you thought that he was so egregiously violating his ethical duty and was questioning his honesty, his trustworthy, and his fitness as a lawyer, why didn't you make the complaint to the disciplinary committee?
Right.
Why didn't you do that, Judge? So
it could, so or did you finish reading? Because I don't want to start.
No, it does not indicate that any such opinion of the court allows removal of appointed counsel without due process and against the wishes of the accused. Judge Gull has violated rules 1.2, 2.2, 2.3, 2.6, 2.8, and 2.11 of the Indiana Code of Judicial Conduct. Swear and affirm, Brad Rozzi. So there you go.
So, I do think, there's a couple of things here. So, just because the judge hasn't reported him doesn't mean, at least she could argue, doesn't mean that she didn't intend to once the case was over or whatever the case may be. So there's, so there's that, but, that could be that is a good point to make, but I just think it's a very easily responded to point. Like, oh, don't worry, I intended to, unless it was part of what she was kind of the quid pro quo of withdrawing, was, and then you don't have a removal, and that gets reported to, to the disciplinary commission. So I don't know.
So let me ask you this, babe. What is the next? So these get filed, okay, and they're direct attacks on Gull. Like, who's hearing this? Is the chief
in theory judge? It should be the chief judge
in Carroll County? Because remember, she is not a Carroll County judge.
Yes, it should be the chief judge in Carroll County.
Right. So this motion to DQ. So what I want to know from your brilliant ability to be able to research, is Rousy in or out right now? I don't think that he is out.
There was one lawyer who she said at the end that he was going to make a written motion.
Rousy.
Right. So he is still
attorney of record. Right.
He's still the attorney of record. And we kind of commented on that before. Like, well, why did she just say there's no lawyer left if technically this one lawyer hasn't left yet? And we just thought it was like, well, it was decided that he'd be leaving. So that's why she did it that way. But it's very bizarre. It's going to make for an interesting motion in front of whoever it is heard by, but it should not be heard by her, because if you go up to the top, it also asks for removal. In the top of the motion at the very beginning when he, well, whatever. So it asks for. It says that they respectfully move for recusal of and change of judge. So, they're asking for the judiciary to change the judge. And they're going to have to prove enough so that they think that there is at least the appearance of impropriety. It's a very high bar. It's not usually granted. But there are a lot of,
dude, this is a different thing. Oh, sorry. I called you dude again. Jay was giving me all kinds of crap about calling you dude. Again, I call everybody dude. Dude has no gender to me. Everyone's
got it.
Right. But new people. All right. So look, I'm shook. I'm shook with this. I'm beyond excited for Richard Allen that this guy is sticking with this.
So people, there's a lot of people on the other side of this who are like, well, you're only getting the one side and you're accepting everything that the
who in the chat right
now? No, in general. There's probably people in the chat as well, but in general. And here's the thing. This is a sworn statement. So these things were said and done, whether, you know, the intent behind it or how egregious it is, that's all, you know, that's all up to the opinion of what's going to be a different judge. But the fact that there was a that she had a I don't know if she wrote it out or
yes,
yeah,
she had a written
statement that she was going to read. That is a fact, and it is a fact that is sworn to by an officer of the court. He is going to, you know, make that up.
He's not making any of this up. Anybody who thinks that he's making this up is out of your minds.
Right.
And no lawyer's doing that.
Trying to explain in a much
better way. Like, you don't know, forget all the niceties. Brad Rozzi's not making any of this up. And beyond that, babe, didn't we see that there was like, there is an audio recording of all of this? Did you see like in what we were emailed today?
Yes, there is a motion that was filed. So when you're indigent, you know, you've got to put in requests to have transcripts done. So they filed what's called a precipice for transcript, and they requested the transcript of the in-chambers hearings and said both parts, that there are 2 parts on October 19th in front of the Judge Gull, including the original recording and the transcript itself. So, which is that, by the way, is unusual that they asked for the original recording. But I am not surprised. There have been times, you know, where, you know, specifically at least one time where I was certain that something a judge claimed that I said that was audible, and she was able to verify through the recording, I didn't believe was on it. So I actually asked for the actual recording, and they told me, oh, we don't have that recording. I don't know how they have a transcript without a recording, or how one day the just court recording system stopped working altogether in the federal courthouse. But you know,
it happens sometimes conveniently. Boy, I had a couple.
It really doesn't happen.
Like
that doesn't happen.
Convenient timing.
It doesn't happen. All of a sudden, the federal courthouse, just the whole transcript process went dark.
All right, so like, I don't know. I'm gonna go on here. I don't even know if any of our mods are on here because we gave them no. So we got 540 people viewing and 179 likes. Like, really? Seriously, please. It's super helpful to the algorithm if you just hit that little thumbs up button. Like,
all right, but
540 people, like, please give us the likes. Please subscribe to the channel. I'm not afraid to beg.
All right, you're begging. So Charmaine asked a question. She says, well, and a comment. I'm glad that Rousy is staying, but he's picking a fight with Gull here. Can that negatively affect them in court if she is the presiding judge? Well, the answer to that is yes. And it is not something that lawyers do lightly, because we know, even though there shouldn't be, and, you know, like, judges are just people too. And if you piss them off, it's not going to go well for you.
We're all just people. Everybody in the system is just people. Like, people seem to forget, like, people have feelings, people have reputations that have been built. You know, when people cast aspersions on anybody, you know, it's like, I mean, this response to me was such a big day for defense attorneys around the country, to be honest. And I'm not overstating that. I'm really not. You know, I mean, like, I cannot. And if you all are late to the party and you didn't kind of catch the beginning of it, I'm going to just restate it real quickly. I'm obviously not reading the documents. You can go back. But if you're just coming to the live right now, Brad Rozzi has filed multiple documents today. The first being notice of his intent to stay on as counsel for Richard Allen,
wherein he called out the judge for forcing the other attorney's hand and giving him no choice and strong-arming
both of their hands. Yeah.
And then a second motion to disqualify the judge for her lack of impartiality. And so he's asking to have the judge removed from the case and a new judge assigned. And then we've got Desiree, who I think might have left.
I think she had to go to work, but
yes,
she's amazing. Like she came in again, huge.
And she noted that, she found this to be a day for justice. And she was glad that Rousy showed the courage that all of us need to understand.
And look, again, and I say it on every live stream, I say it constantly. The only thing we care about in this case is justice for Abby and Libby. Like, please just understand that to get to that point, they have to have the right guy. And if he is the right guy, if Richard's Allen, like, we want to make sure that he has good counsel, competent counsel, and that there's a fair trial.
Right. And it's not for the judge to say, and I have seen it. I have been the victim of this myself, where a judge is just like, who is the judge to be commenting on their defense, decisions of how they're going to run their defense and the evidence that they're going to put forward, and whether or not they should be, having certain theories of defense. It's ridiculous. And I remember one time.
Explain that to people, because remember, we're lawyers. We understand that is improper for a judge to be commenting on a defense strategy or a prosecution strategy. It's
right,
just
or
it's
a
improper.
Theory of the case. That's not their
role. Job.
And judges, judges get in their minds, like the judge may just have in his or her mind. I don't know that it's she, right? The judge.
Yes.
Right. I saw her on TV, that she is familiar with Rousy and Baldwin or not. And she may have in her mind that these guys are full of shit, and that she thinks that their pleadings are full of shit. And that's bleeding through into everything and every way that she interprets what these lawyers are doing. And Bob and I have seen it firsthand. And we've told stories before about a judge who just decided that, we were full of shit for whatever reason. And then come the end of the next trial in front of him, he was applauding us for being, such valuable members of the defense bar, and, that more lawyers should be like us. So, it's not necessarily like this judge just, is involved in this like big, huge conspiracy or whatever the case may be. It's just, she has let her personal opinions just in here too much. And it's accurate. Like, how come everything that the prosecution, obviously there is nothing as, in depth and explosive as the memorandum that the prosecution has filed, but there might be filings that the defense can point to say, why would this pleading be removed from the docket? Why would this be sealed while the prosecution's filing that's, includes facts of X, Y, or Z nature, is not sealed? And at the end of the day, whether this is going to carry the day and get a new judge, who's to say? I would like to say yes, because I think there is the appearance of impropriety, even if that appearance of impropriety has now been sort of like pushed along by the defense's filing, by bringing all of this out. But nonetheless, if they're supposed to take the appearance of impropriety seriously, something that should be considered. And maybe this lawyer is going to catch, a lot of shit for sort of creating the appearance of impropriety through his filing in an attempt to gain support for his position. But there's no other way to do it. It just so happens that this case is under a microscope, as a lot of the nationally covered cases are, but it's what you have to do. And you have to put in your pleading the basis for your motion. You can't just write sort of a vague, motion and then be like, well, I didn't want to say all that shit in a record. I didn't want to put it all in a pleading, because otherwise your pleading is, defunct on the face of it. So,
yeah,
so
what's next here is what we're going to try to figure out right now. So we've got a hearing for 1031. Woo! You know who's going to be there for that? This guy, because it's back in Carroll County, and man, oh man, Oh, I feel like having like a little parade outside of Brad's office, like a one guy parade with a little like, I'm just is a longtime defense guy who like both of us has just been beaten down over our careers, and people just don't get it. Like unless you've been on the defense bar and this side of it where everyone hates you and everybody, just always associates you with the criminal. They don't know what we do for a living. This is a banner day. This is a banner day for number one, Richard Allen, number two for Abby and Libby, because this guy needs to stay on this case. This will get rid of this delay. This thing let's get to
I'm
trial.
surprised he's not trying to get the other lawyer back in as well. We don't,
I mean,
don't know what
like maybe Brad's got a tougher road to hoe. Or Andrew's got a tougher road to hoe. Like he orally withdrew. I think there's an argument, and I'm surprised Brad didn't make it, that I don't have to get reinserted in the case, because
that's what he's saying. That's why he entitled it. I'm sorry, babe. I cut you off mid speaking, but he entitled it notice of continuing representation.
Right.
So it did not need to include many of those facts, which I'm sure is part of what's going to be sort of, when people come down on either side of this, part of the point is that he could have just said, I'm continuing to represent this guy, period. But clearly this lawyer feels that it is very important to bring all of this stuff to light. He wants this out of the shadows. And if it's being said and it's being done, then guess what? I'm putting it out there. I'm not allowing all of this to stay hidden in the background. Right. And, whether he gets, shit for that or not, whether it was all necessary in order to give his notice of continuing representation, who knows? I mean, I have never, ever heard a judge say, even when they were, like, hey, you guys have to cease working on this case at once. Like, don't do anything further. And I think I asked, and Bob, do you know, Bob?
What?
Do you know what date the leak was in relation? Take down this certificate of service here that we're all staring at.
Do we want to get rid of it completely? All right, hold on.
Yeah, when the date was of the leak, because he said, if you go back to the other pleading, and I'm just going to look at it instead of you having to pull it up, but that the judge sent that email on October 12th.
So wait, you're asking the day of the leak?
Yeah.
Sleuthy, if you're in here, just throw us the date. Like Sleuthy, like her, if I wish I could get her thing up because it's amazing. Otherwise, I got to pull it up. Sleuthy's probably still in here. Sleuth, when was the date of the leak? She'll give the answer.
All right, well, then give her a chance to figure it out.
Okay.
I was just wondering how close in time it was to the judge's email. So it says this person wrote, Jewels of all trades, true crime. The leak was reported to the Indiana State PD on 10/9 is what she thought. Charmaine said October 5th. So either way, I mean, this is shortly thereafter where the judge is saying stop doing.
This is an interesting question, Allie, that I kept meaning to ask you about, that I thought was very interesting. See it? It's up on the screen.
Yeah, I'm sorry. I was looking for my hair tie because it's really hot under these lights.
Intense light.
You've got me.
It just magnifies your beauty for the whole world to see.
All right.
Oh, yeah.
So how is McLeland even trying this case, as he's related to one of the victims' family and was raised by Brad and Terry Germain? This is
German.
Sorry.
That's interesting though, right?
I mean, if it's all accurate, they wouldn't let him be a juror.
No, but
you know what I mean? Like,
he's the prosecutor.
I understand. I'm saying if you can't even be a juror with that much connection to a case, he probably shouldn't have been the. But you know what? At the end of the day, technically, Brad and so, if he's related to the victims.
All right, so instead of just floating around aimlessly, so the 31st, let's try to give a summary of what we think is going to happen. Let people get back to work. So again, Huge filings today. But as far as I'm concerned, Brad Rozzi still is attorney of record for Richard Allen.
You know what? I'm sorry to pop in here, though. What the hell does this mean that she ruled on motions? The ruling on motions in chambers and then not. That's like,
I don't know.
What motions did you rule on? I mean,
He doesn't put anything in the docket.
I've never seen anything.
She doesn't put anything in. It's what I was bitching about last night, that there's no docket entries. There's like trying to follow this case in the docket is like trying to read hieroglyphics from an alien race that was left 4,000 years ago and was buried under under the sea and then got pulled up by Neptunians. And you can't read her docket because she doesn't do anything on the docket. They're like, she doesn't set anything for hearings.
So for all we know, she has ruled on some of the, because he put in there that those motions went unaddressed. So
can there be, if there is no court order, how can anything there has not been one court order entered on the docket, which we look at daily, with relation to what took place on 10/19. None, no docket, no court entry saying, hey, Baldwin's out. Rosie's
there was a
out.
minute entry, wasn't there?
I don't know. I don't think so.
Either way, it didn't say anything about her ruling on any substantive motions, which is what this motion indicates, or the notice indicates, was part one of the in-chambers hearing. He called it an in-chambers hearing.
Yeah. Okay, let's see. I'm trying to see if we got anything else. All right, I'm gonna give some love to Angela like 2 times. So do you know how insanely amazing Angela Patrick is? So new member, and she, I'm pretty sure she gave us 50 last night, but then gave us 50 giant super sticker. She loves she loves our Bay relationship, and then he gifted 5 Defense Diary podcast memberships. Smooches and hugs to you.
Wow, that's
$50 holla. That's a $50 screecher. That's what we're gonna call it. So thank you so much, Angela. Mandy,
anything that makes Bob that crazy thing he just did.
Yeah,
the little
Mandy, you're amazing. We love you. Thank you so much for that generosity, and I'm glad that you're hanging with us today. And I'm always here for you, kid. Just remember that. If you ever need somebody to talk to or a shoulder to cry on, I'm your guy. Charmaine, of course, thank you so much for your generosity. You're always giving. You give till it hurts with the $5 holla, and then Desiree with the $10 holla, and then she kicks it back with the $5 holla. I mean, y'all are just so incredibly generous. I cannot.
So we haven't talked about Danielle's comment yet. You want to
Where
read
is
that?
it? Oh,
it's
yeah.
right
I'm about to give Danielle the love. Like you always.
Sorry.
Jump ahead, her Captain. Jump ahead. She likes to jump ahead. All right. Thank you for covering the saga with the attention to detail and integrity it deserves. Rosie is a credit to our profession, and I'm so proud of him too. Danielle, yes. Number one, thank you for the $10 holla, and thank you for writing that. I mean, we feel the same way. It's an amazing comment. Obviously, Alice and I are very biased for the defense bar, with good reason. We are out there fighting the good fight. People want to hate defense attorneys, and I've changed, I don't know how many minds on what we really do.
At least 2.
At least 2, like yours and maybe like one of our kids.
No, you've changed a lot of people's minds. I've seen.
I know.
It's
not about changing minds. It's about educating.
Right. And people just saying, we're not saying we're defense sided, meaning we're always going to defense or something like that. But we just have a very clear understanding of the
law and how it operates in the judicial system and the realities of that system. That's what we know.
And the disadvantages to not only defendants, but to their attorneys that are inherent in the system. And that's before you even get to race, which is a whole other
thing
world of injustice in the system.
Well, it's race, money, all of it.
But it all starts.
You are going to have a better defense if you can afford to pay a high-powered attorney. It's fact.
But you're still going to have the court treat that defense attorney the same as less than the prosecutor,
right? Which is absurd. Which is just absurd. Like prosecutors are not special people. They're normal people that go in and they represent the government. Like people just forget We represent the people. All of the people of the country are represented by defense lawyers, even though the state always says it's the people of the state of wherever. Make no bones about it. And I've said this a million times, the prosecution represents the government. And if you're a big, huge pro-government person, good on you. And like, do I appreciate the fact that they have an incredibly important job to do? Of course.
Yes.
There are many
but do it fairly. Do it
horrible
fairly.
people. There are many horrible people out in the world that deserve to be punished. Some of them deserve to be punished for their entire lives. And we need prosecutors out there. But like, let's just not forget that with every profession, with defense attorneys, with prosecutors, with law enforcement, with judges, there's good and there's bad. It's that simple. The concept that every prosecutor is above reproach is absurd. And same goes for defense attorneys, and same goes for the cops. Like I had a guy, Robert, who was kind of coming at me last night, and I was like, "What are you saying?" Like he was up, like, and you don't like when I respond, but I like to respond, and it's part of the advantage of having a platform is that when somebody comes at me, I can respond, because this isn't an indictment on all prosecutors. I'm telling you that what my gut's telling me about this case, and I'm going to say it again, and now it's been substantiated. Something stinks.
Something stinks in Delphi.
Something stinks in Delphi. And for the girls, we should all care. If you really care about justice for the girls, then you should care about what's going on in this case. Because if you think this is a normal case, or this is all just the defense acting crazy, think again and open your eyes. Like, seriously.
And again, even like we've said, even if there's, overstatements or exaggerations on the defense side, which we're not saying there's not, it doesn't change the fact that something stinks in Delphi.
Something stinks in Delphi. And you know what? The garbage is going to the bag's going to get opened on the 31st.
Well, that's what he's doing with this motion. He's opening
he's about to dump it out on the counsel table and start picking through it and be like, yo, this dirty diaper, whoop, we got to get, it's all going down. Like it's just turned from, I don't know what's happening on the 31st of October to like, I'm going to go camp out. Because there is zero chance I'm not going to be in that courtroom for what's going on.
For all you know, they have been contacted by the chief judge's chambers to appear before the chief judge, and
whatever
that motion, it could happen.
Well, yeah, right. And the problem is going to be, will Gull enter an order on anything? I mean, so like,
while this motion is pending, she can't do anything. That's typical practice.
Just so y'all understand how this thing plays out. Like, Gull probably did not get a courtesy copy of either of these two filings that came through last night. Like, so like Judge Gull's clerk probably like, not, Judge Gull, I have a couple of things that Brad Rozzi filed. Come on in, bring it in.
All right.
She gets handed these things. But what my point is that she had as much notice as Brad Rozzi and Andrew Baldwin had about her trying to DQ them off the case, with her getting this like delivered to her by her clerk or an email or like, oh, you may want to see this one, Your Honor. I mean, however she got notice that these things were filed. Whoo, man, how to be a fly on her wall while she's reading through this stuff, man. Oh man. And like, I mean, what is your honest opinion? Do you think that she's been like, if you look at her background, she's certainly pro prosecution, law enforcement. I mean, that's, judges just fall one way or another. I mean, you'll have and lawyers in counties know if you have a defense side judge who's lenient in terms of sentencing, who will grant motions to suppress. And you'll know if you have a stateside judge. And she is historically known to be a very pro law enforcement, pro prosecution judge. So, I mean, and I'm not taking that into consideration at all. Forget all that. What I'm saying is that based on what we've just gone through, and I know I asked you once already, I'm going to put your feet to the fire because I think that you dodged the question. Do you think there's enough from what we've seen right there for the chief judge to say, I'm sorry, Francis, I'm bouncing you for the safety of the case?
it's super hard to say. I did mention earlier that I thought that when you look at the appearance of impropriety, or giving people reason to believe that she is, more prosecution sided, there's some weight there. But I feel like the judge could say, hey, you're trying to slam her for saying publicly that this was a surprise. Sometimes judges do, and we all know, kind of present things in a way to just kind of shift the way it looks, so it doesn't look so bad or whatever. And they being the chief judge or whoever hears this could see this as one of those things like that was the judge trying to save you face, and until we hear the transcript or see what was said,
It sounds like it was an actual audio recording.
Right, which they do before they transcribe it. So, once they actually do that, it could still be, even though it's a Hobson. That's why I'm saying there's some interpretation here. It's still a Hobson's choice, but it's the same thing we said last night. And whether it was respectfully said or, how the words were parsed, at the end of the day, it's, hey, I'm going to rule. I'm going to find that this is enough to disqualify you guys. So if you want to proceed to hearing.
I don't think it was you guys, though. I think it was Baldwin.
Well, he's making it sound like both of them. That's why he agreed to orally to file.
No, he didn't he wanted to put something in writing. He did not agree to orally. Like Baldwin orally withdrew based on the coercement. And Rousy said, I'm going to do something in writing. So like, he's not, as far as I'm concerned, unless there's a court order that exists, he is still Richard Allen's counsel. Radar, thank you very much for the $5 holla.
Did you thank Jen M?
I will, but he's asking, and I'm going to we have a lot more. We've got almost 600 in here. Please hit the likes, yo.
All right. So what happened, Radar?
Please hit the likes, yo. Allison, quit stopping me from getting people to. We need the algorithm to roll. We have to encourage.
People are doing it.
All right, don't worry about it. Thank you. I love you. All right. So Radar, this is what's going on. If you're late to the party or anybody else, a couple of huge filings today. So Richard Allen's attorneys, in particular, Brad Rozzi, has filed a verified notice of continuing representation, which means Brad Rozzi still thinks he's Richard Allen's lawyer, thinks he has
no intention of withdrawing,
and has no intention of withdrawing, which is great news. And the other equally huge, if not bigger, motion that was filed by Rozzi is they're seeking to disqualify Judge Gull, kick her off the case. She gots to go. So that's where we're at with that. So I have both filings up, Radar, if you want to watch it. I read each of the filings. They're both, I think, worth your time to watch and read. Jen, $20 amazing super sticker. Jen M, you are just a wonderful human being. Thank you so much for that generosity. I really, really. Oh, our friends, our amazing friends over at Criminality, another great YouTube channel. I love hanging with them. Like, they should have me back on. I'm going to have them on our show too, because she's great. And I've been on her show, and she crushes the game. And she's deep into the Delphi stuff too. Thank you so much for that $10 holla. And then we got Aaron. Thank you so much for becoming a member. That means so much to us. Like, we love to see it. We're so close to 5K subs, babe. Like, I mean, if everybody on here would just sub, because you're going to get good content from us, like, guaranteed. Like, and again, there may be things that you disagree with us about, but it's going to be good content. It's going to be informed content. We're not.
And really just go listen to the podcast, because that's where it's at.
Yeah, the podcast is really, really good. And then we got another $10 holla from Mimi 62. Oh, we really love you. Thank you so much for that money. All right. All right. So do you want to wrap this? So end of the day, I don't know what's going to go down on the 31st. I have a feeling that you're right, This thing should be getting kicked up to the chief judge's chambers. We should be doing some research to see who the chief judge in Carroll County is, because I would really like to see what's going to be going on with that. I would imagine that going into that here, like, this has to be dealt with.
It has to be. It can't
before she's.
My understanding is that this judge cannot rule on anything while this motion is pending.
Okay, so that's
the typical way this type of motion would work. So,
right. I mean, how can she? There's like, we've called her into, like, there's a question of whether or not Alan still has counsel. Like Rousy says, I am counsel. Gull's going to say you're not counsel. And then we've got this motion DQ. And
as we stated yesterday, for anyone who wasn't there, there is an issue. You have the right to your counsel of choice when you retain counsel, meaning you pay and buy your own, or whatever, your lawyer is working for you directly. When you are having court-appointed counsel, be that the public defender or through whatever other means, you do not have the right to choose which particular lawyer is going to represent you. However, once the representation is established and the attorney-client relationship exists, there is case law out there, and there's a split in the circuits about what means what, but that the judge can't unilaterally remove and change and force the defendant to have another public lawyer if the defendant and the lawyer aren't asking for that. You know, if the lawyer's asking for that, in theory, the court's going to have to then weigh that against the defendant's right to continued representation of preferred counsel. That's the difference here. We're talking about the continuation of counsel, which he has already secured, which he has already developed a relationship with.
Let me jump in like real quick, and like, I'm going to throw you a huge curveball. So what happens? Like, so somebody just put in here, and I don't know if it's true or if it's not true. So the judge who recused himself, Judge Diener, what happens if he is the chief judge?
Then he'd probably hand it to another judge.
Who? Some schmuck in Carroll County? Like some, like, we're talking about a very small county. If
he's recused himself over the case itself, then he just has to decide whether he can be fair and impartial in deciding whether this judge should be recused. I mean,
oh man,
I don't know.
That's tricky.
That's tricky, right?
We're talking like smaller than Kendall County. You know what I'm saying? Like there is a very small amount of judges there. And man, like, that is tricky. So that was a great point. I want to give love to whoever put that up. I think it was, Aaron brought that up. So good one. And she's a member. We have a couple of, so Cassie, I think that this will happen in Carroll County, not in her county. Like her county has nothing to do with it, other than they're going to pull the veneer from Allen County, meaning that the jury pool is going to come from there, and she just happens to sit on the bench there for all intents and purposes.
Did they appoint her through? They've got like an appointment of special counsel. It's like Rule 7-9 in Indiana. Do you know if this judge was appointed through that? Because I do, like you said, I mean the pleadings all still note Carroll County, which means this is a Carroll County case being
it's 100% a Carroll
presided over by a. Right.
Yeah. No. I mean, they realized that they needed somebody from out of county for various reasons. You know, I mean, like the thought being, oh, here, I thought this was a super interesting comment by Kate. Read through it. It's an interesting concept. My answer would be no, because it's way harder to get back in. Like, you know what I'm saying? It's like what her concept is right. You know, that it would have been more prudent maybe for them to say, okay, you know, bring us out, whatever. But once they're removed,
no,
it's way harder to get back in.
Right. I think what she's saying, and I agree with what she's saying, that this is the prudent thing to do, is for them to force the issue, get a lashing for it, and then make a record and make the judge remove them. Make the judge.
I don't think that's what if this account is accurate, wouldn't it been more prudent for them to force the issue and get the lashing in? I think she's saying on record and remove them. I think she's suggesting that they should have taken their beating on the 19th and then tried to figure it out. I think that conceptually I understand. I think that's what you're saying, Kate. If I'm misinterpreting you had a couple of typos in there, but if I'm misinterpreting what you're saying, like, let me know.
Then the answer is yes, but it sounds like they were, things happen.
I disagree. If once you're out of the case, it becomes way harder.
No. What she's saying is, like, if we're taking it the way you just said, tell the judge no and force a hearing in front of in public, like the judge said that they were going to have, and then there would have been a record, and then the judge would have disqualified them. That's right. Probably what should have been done initially. Yes, I absolutely think that's what they
should have been done. By whom?
Neither lawyer should have withdrawn or said they will withdraw because the judge gave them a Hobson's choice. They should have said, no, let's do it in front of the cameras. The truth is the truth.
How do you get back in the case if you're DQ'd?
But she would have had to DQ them. She still might.
Okay, well, I'm going to completely disagree with you. I think Rousy played it like an absolute champion. Baldwin bid on it and made an oral motion. Rosie's smart. He said, you know what? I'm gonna do it in writing, Your Honor. He padded the hand. He stayed his execution as far as I'm concerned by doing that. And like, he's got like, man, what a day for defense lawyers all over this country. And for
he took the power away from the judge by making her think, okay, I'll do it, but I want to do it in writing and I'll do it afterwards. Okay, yes, I'll do what you say, Your Honor. And then he did a flip up or whatever it's called.
Canadian girl, you have quickly become my favorite. You're not a member yet. Come on, girl. Like, how can we?
But we're podcasters, so check out the podcast, Canadian girl.
Like, this is all part and parcel. We make these into podcast episodes. It doesn't have to be one or another. Quit trying to destroy the channel, babe. But she's right. Listen to the podcast.
It's much easier to do audio and not worry about what you look like.
Well, it's much easier not to kill yourself when you're driving by listening to the podcast because you can't watch while you're driving. Like, podcasts are great for walking dogs, doing chores, driving, long drives or short drives, doing cleaning around the house, exercising. Those are great times for podcasts. So
Thomas Edison asks,
Thomas was hitting me. It was hitting me somewhere today on Facebook, I think.
So
he was very disappointed in me.
I don't know. But the answer is no, that the chief judge in Carroll County doesn't have any like specific authority to control what this judge does. But that's not
Where's
really
Thomas, babe? I want to put the comment on. You got to star it. You can star it. So I'll see it.
It's yellow. It should be, I don't know, babe. But it says, is Gull subject to the chief justice in Carroll or Allen County? And the answer would be like, no, in one sense, but this isn't like a sanction to the judge. This is a request of the defendant saying, I don't think that my judge is fair. So the judge in Carroll County can squarely look at the facts and decide whether he thinks that this judge is fair and remove the judge because it's a Carroll County case and Carroll County appointed or assigned that judge.
Allen County has nothing to do with this other than what I just said. She happens to sit on the bench there, and that is where they're pulling the veneer from, the jury. Well, that's it.
If the chief judge wanted to give her like a tongue lashing, that'd be her chief judge. And is she Allen County?
She's Allen County, yeah.
In Allen County, or wanted to discipline her or, do anything to her directly. But this is more of the defendant's request that my judge is not fair and I want a different one. It's not like a sanction.
Yeah, it's interesting.
But it's a very good question, right?
Right. And I'd be remiss if I didn't say it. Like, if I am sitting there as the families of Abby and Libby, I'm just like, what in the F is going on?
I'm sure that they're thinking the defense is just crazy.
I don't know that we are. I don't know that the families think that Richard Allen's the right guy.
Well, that's true. We don't.
Does anybody know that? Like, people are like if somebody like in the chat knows for a fact that the families, one or both of them, firmly believe that they got the right guy, I'd love to know that. I really would. I like, because they're reading and hearing the exact same things that we are. in terms of other people that were spoken to, in terms of other potential suspects. They're hearing it all. Like, I'm just trying to put yourself in the shoes, as horrible as it is to think about, of being one of the victim's family members. And you're sitting there hearing that maybe there's more to this.
Like, and even if you think that Alan's the, sorry.
Go.
I was just going to say, even if you think that Alan's the right guy, these types of things are appeal issues. You don't want these types of issues. If they do have the right guy, it needs to be fair. It needs to be clean so that there's a conviction and a conviction sticks. So these issues we're discussing now are equally important, regardless of which side of the fence or camp you are on. But I will remind everybody, the man is innocent until proven guilty. And none of us, not me to say he's innocent and not anyone else to say he's guilty, has heard all of the evidence. I can say off the evidence I've heard that I don't feel the presumption is great enough for him to be held without bond, in my personal opinion. But I have not heard the evidence to say one way or another if they have the right guy, just that there seems to be, questions. But even if you're of the opinion, like, you know what, I really think this might be the guy, because none of us have heard all the evidence yet. These issues we're discussing today are equally important, because you don't, and we don't, and no one wants the right guy to have to go to, for there to have to be a retrial for the family to go through because he was denied his right to counsel, or because there was something unfair about the process.
Right. I mean, do you guys understand what Allison's saying? She's saying if Richard Allen is the guy, he is the correct guy. If he is the man who murdered both girls, and they screw it up because Gull removed his attorneys, and then they have to retry him, that's a problem. I mean, that's what we're trying to say. It's like there's so much going on with this case, and you want to get it right the first time, whether Richard Allen is the guy or he isn't the guy. I happen to think that he is not the guy. That is, like, I am firmly in that camp. I am sorry. But remember, I have not made a final decision until trial. No one can.
Right.
Exactly what Allison was saying. Like, all of us are allowed to have our initial instincts. And those of you that find the PCA to be very compelling because he made a voluntary statement and put himself at the scene, and they have an unspent shell casing that they'll never be able to match to his gun. If you find that super compelling, and that there's 4 people who identified the wrong, like, different looking guy on the, like, I get it. Kind of. Like, why you think Richard Allen's the guy. But I just don't feel that way. That being said, they could have smoking gun evidence that Richard Allen is the guy. And then there's always the confessions. Now, like, I'm not going to get into the thing. Allison has said it just ad nauseum, and she's 100% correct. Until we actually, all of us, hear those and hear the tone, the context, the tenor, everything that's said, we have no idea what those are. We know that there's been a statement that he's made confessions over a recorded call, and we had the defense saying we acknowledge that those exist. No discussion whatsoever about the content, the tone, the tenor, any of that stuff, or whether or not he had a big Odin guard saying that I'm going to murder your family if you don't say it. Like, we
have the wife that he said it to still acting as though she very firmly believes in his innocence. Now, and thank you, Mandy, but let's go to Buried in
2 times. Mandy came back. She doubled up.
I know, I saw, because she's not doing Patreons anymore. Understandable.
I was sad when she left, but I understand.
Yes. And then Buried in Oklahoma asks, can Gull file a complaint now to get back at Rousy? Whether it's to get back at Rousy or not, she can file the complaint now. She could file it, a little bit later. It is typically something you do right when it happens. I'm sure the judge has an obligation to report that type of conduct. It's been, 2 weeks, so I just don't know that it's long enough for them to kind of establish what they were arguing in the motion. Like, hey, she thought it was so egregious that she's forcing lawyers to withdraw, yet she didn't file an official disciplinary complaint.
Hey,
I'm sure she'll say she planned to anyway.
babe, do you have the docket up still? Do you got the Carroll County docket up?
No, but I can in a matter of seconds.
Can you pull it up? Like I don't know. I don't know what Lynn GMB. I think Lynn is a pro. She's reached a final conclusion that Richard Allen's guilty. I think if it's the same person. So she says clerk of Carroll Court ordered to remove Andrew Baldwin and Rousy as attorneys of record in this cause. Like I don't know if she's just typing that or if that's real. So I want you to look at that because we're all about facts. We like just facts here. And I want to check that. Let's see if there's an order to go.
Oh, by the way, there's the petition for expungement and sealing of records of Richard Allen, August 2023. Is it Richard? No, that's a different Richard Allen. Wow, there's a lot of Richard Allens.
Yes, Crazy Sheba.
What's his middle name?
M.
Okay.
Allen.
Or let me refine my search here. Richard M.
Missing people. What judge's orders? These are not judge's orders. These filings were by the defense today. That's part of the problem. The judge never makes court orders. She'll do minute orders where she types in. There still isn't an order from the 19th. So to go to
hey, there's an order. There's an order.
What's it
all
say?
Right, updating. The court notes the following pleadings, which may be resolved without further argument or hearing. 1. So these are the things that I think so that's remember we were saying earlier, like, where is the order of all these rulings she gave in chambers? Okay, so
can you get it to me somehow?
It's the docket.
Okay.
I can copy and
no, you read. I'm going to try to pull it up on second screen.
I can email it to you right now.
Okay, let me see.
All right, I'm emailing this to you.
I'm gonna try here. Hold on.
All right.
This takes a lot of technology. No, you read and I'll do the other stuff.
All right. Well, I've already emailed it to you.
Okay.
Send anyway. No subject line. All right. So what it says. So first, these are the orders that they entered. Defense motion for broadcasting order is overbroad. Therefore, the motion is denied. Motion to quash subpoena requested by the state for defendant's medical records is granted. The state's not entitled to the records. Defendant's verified motion for immediate transfer of custody is denied based upon the state's response and the attached affidavits. The defense multiple motion for a Franks hearing remain unresolved as the court is still reviewing the thousands of pages of exhibits attached to the motion, as well as the multiple hours of digital evidence submitted by counsel. The court will continue to review same. Defendant's motion to suppress and supplemental motion to suppress, as well as the state's responses, will be set for hearing upon resolution of the Franks motions. Prior to the scheduled hearing date, attorneys Rozzi and Baldwin advised the court that they will be withdrawing their representation of the defendant. The court accepts their representations and orders them withdrawn from the cause.
What?
Counsel orders.
Wait, I missed it. Oh, damn it.
The court orders them withdrawn. I thought they said something about the other lawyer doing it in writing at the. I don't know. So she's like, entering these orders now that are signed from 1019. And that's like, hey, you couldn't file anything because you withdrew. So I don't know. The court accepts their representations and orders them withdrawn from the cause. Counsel ordered to comply with the previously entered protective order on discovery and are ordered to turn the discovery over in full to the state of Indiana to be made available to successor counsel. Court requests their cooperation with successor counsel in the best interest of their former client, but is not requiring them to cooperate. Court will maintain the hearing scheduled for the 31st in the Carroll County Circuit Court for successor counsel to appear. The clerk of Carroll Circuit Court ordered to remove Attorney Baldwin and Rousy as attorneys of record in this cause. And now, oh, she did it twice. And then
It's
it's
the same word. Yeah, that was panic. She
right.
panicked.
Yes. Then it says
I can just see it. Yeah, it's
entry
a little late
dated
for that, Judge.
October 19th regarding order issued, entered twice in error.
Wow, dude, this is like a heavyweight fight now. This is a straight up heavyweight. So email it to me again. I screwed it up. I don't know. I archived it or some shit.
What?
Like email me the order. Like, do we need to put it up?
No, I just said it.
All right. So what was the bottom line it for me? Because I was like half paying attention.
The judge withdraws them. She accepts their representations that they are going to withdraw and orders them withdrawn and directs the clerk to remove them, which would not allow them to file, I guess, any more of record. So.
Unfortunately, so she did it where she backdated the order to the 19th.
Well, supposedly, like we were saying before, where is the order relating to this, the rulings that she made in chambers, and this is that order. So yes, it is dated the 19th and entered today.
Okay.
Took her a while.
Yeah, you know what? I'm sorry, but Brad beat you. I mean, like docket in terms of when you file matters. Like people need to understand that. Like Brad got his documents in before she filed that order. Like he in time, he beat her in time. This bracelet is made by one of Jay was giving me all kinds of shit about it. It says badass. My friend from Navigating Advocacy, great podcast. She made it for us. It says DD. I like it. It's cute. I'm not above wearing adorable things. All right. Let's see. All right. So that's wow. So what does that mean? What does that mean, Allison?
Well, it means is
he? Like you didn't acknowledge the fact that it does matter who files first.
I know, but the judge is trying to say this was her order on the 19th, but I have read case law that oral rulings don't rule the day. It's the written order and the date of the written order.
But that's what I'm saying. She's doing it like basically nunc pro tunc, like nunc pro tunking her ass back to the 19th. Like what she said on the record was that Andrew Baldwin made an oral motion to withdraw, which she granted, but that Brad Rozzi, because she comes in and says they both withdrawn, which I think she was out of line.
Clearly,
I think she misrepresented what was happening, like on the record, and then said that Brad wants to write a written motion to withdraw. So by way of that, you can't have it both ways.
Right.
And when she didn't file an order, because we're sitting on Thursday, she had Friday.
He was waiting for him to file
Monday,
motion.
Tuesday, Wednesday, and then she waits until Brad Rozzi files something, and then she finally enters an order and gets off her ass and finally addresses the other 50 things that are pending. So I don't know, man. This is going to set up to be one heck of a cage match on the 31st, and I'm there for it.
Unless it's done sooner. You got to try to figure that out.
Ah, man, I don't
Maybe
know.
I'll call the chief. Maybe we'll try to reach out to the chief judge's chambers. I don't know.
The prosecution is confident they have the right. How do you know that, SP 74?
I'm sure the prosecution is confident.
Are they?
Are they? They're playing it that way.
Are they? Are they confident?
Who knows?
I don't know. I mean, maybe
they want to. They're in their actions.
Yeah. Okay. So let me see if we got anything else. So that's another stunning. That was like breaking news. So I actually have to thank, even though we have a extreme difference of opinion on things, I want to find her because she was the one who alerted me that order came out. So good on her. We may not agree, but I always appreciate
Carolyn Jansen's. Is that her?
No, Carolyn practices in our county, dude. You don't know Carolyn Jansen's? Like seriously?
Oh, she's a lawyer in our county.
Yes.
Oh, yeah,
He's going to be
Carolyn.
super offended that you don't know who she is.
No, I do.
Okay. I know who you are, Carolyn. Hi. No, I'm talking about Lynn. Lynn is the one who was kind enough to let us know that the new order came out. So, I mean, she was giving it to you like, ha, too bad type thing. But like, nonetheless, it doesn't matter. I'm glad that she put it out there. Because again, this is all about the search for truth. If anybody cares about the truth, I mean, then we have
And
to.
what's going to prevent him from deciding to remain on pro se?
Who?
Or he can be, he doesn't have to be court appointed counsel.
Right.
She can't control that unless she's going to.
What does that mean? Is that like, what are you talking about? Like Richard Allen's going to represent himself?
No, his lawyer is not court appointed. He's doing it. I'm sorry. I said pro se, pro bono.
Okay.
Sorry.
Thank you.
My bad.
Thank you.
Get my Latin mixed up this morning.
Yeah, but I understand the Latin. So when you said it, it didn't make any sense to me.
Right.
But now so wait, I missed that. So wait,
Yeah.
Rosie said he's coming in pro bono?
No, I'm saying if he comes in pro bono, the court doesn't have any control unless she is literally going to disqualify him.
Right.
Because they're trying to do like, well, you're court appointed, you're not appointed anymore. Well, guess what? Then I'm retained.
Right. Or like Richard Allen gave me $1.
Right.
$1 holla. Now
he can decide to do it pro bono.
Totally. 100%. 100%.
Maybe he should.
Maybe he should. I mean, God, that kind of beating though. And we were like, you were so articulate about it last night. Just like people don't understand that a type of case, like it's a practice killer. It's an absolute
Richard Allen should really send something in directly to the court that says that I object to the removal of my lawyers. I demand my right to continued representation by attorneys Rousy and Baldwin, or whatever he wants, just to firm up the record. But it looked like in a notation in the motion, it says that there was already a letter or an affidavit from him that they.
Correct.
Right. So it's a record that he is requesting his lawyers remain attorneys.
Which goes to that entire Sixth Amendment argument that you brought up last night about, because
continued representation,
and did it transition from them being appointed attorneys to now they are the counsel of his choice because they've built this relationship over the last year and 3 months. All right. So do you think we're good here, Ben?
I think we're good. But I just want to make sure I didn't, like, Thomas says something. Okay.
Thomas, $5 holla. Thank you, my brother. Appreciate you, man.
And then
I want to see if there's any other ones that we missed.
There was a sticker. I'm looking for
another
questions.
Buried.
Yeah.
Tiffany, is that you? Like, I think it's Tiffany. She's oh my God. Like Desiree is just too much. Desiree.
Thanks again, Desiree.
I mean, you remember she kicked us 50.
Yes. We talked about it again this morning when we weren't on.
Desiree, like
when we were in our kitchen and I was making breakfast.
Thank you so much. That is so incredibly generous. Thank you. Wow.
So JB asks, okay, could Judge Gull be removed? What is the process or circumstances for that to happen? So they have filed the first step to make that happen. And in theory, it should go before another judge to decide whether or not, there's enough evidence of her not being able to be partial, that she is impartial, or that there is the appearance of impropriety, meaning that it looks like she can't be partial and it looks like she's being unfair. It's a very high bar. It's a very not typically it's like you have to show that this judge like personally doesn't like you, like having nothing to do with the case. He see you on the street and was like, that you are, I don't know, I can't think of something, but it's like not that they disagree with you, you're like attorney style in general, but they have like a personal issue with you. But the rule that they cited in Indiana seems a little bit more broad, in that it does encompass the, appearance for if there's any reason to believe that they might not be, partial. But typically a lot of times they look at the, extrajudicial conduct or circumstances or, things like that.
What's extrajudicial mean, Allison?
Outside of the courtroom.
Okay. All right. Thank you, JD, for that. That was awesome. So, no, that wasn't JD. Why is this such a bombshell if they've already withdrawn? So, which question is that, JD?
Let me answer,
But
because
like we don't know if JD just missed the whole beginning.
right, he might have. That's why I'm just going to
Or
say,
she. I don't know if JD.
or
It looks like
she.
a
It looks
female.
like a
to me.
she. Hi. That all of this is a bombshell, no matter which this we're talking about right now, because was it Baldwin, babe? Is Baldwin the one that didn't withdraw? Rousy. That Rousy didn't withdraw on the 19th. He said, at least what was said when the cameras were rolling, was that he intended to write a written motion regarding his withdrawal. And he never did that, but instead filed notice that he is continuing to represent this client. So that's why it would be a bombshell. And that's why he is presenting that he is not withdrawn and has no intention to withdraw and will be continuing to represent Richard Allen, while the judge on the flip side is saying, well, I've already ordered you withdrawn. So now it's like a battle of the filings. And again, my position is that if Rossi wanted to remain private counsel and not through a court appointment, there's nothing the judge can do except to officially, of record, disqualify him, for which there is no basis, it doesn't appear, to disqualify him.
I mean, he's not making much on it. I think somebody
Right.
said he's making about $1.70 an hour.
I mean, if he's been practicing as long as he has and he is this much invested, he might as well just stay on as private counsel.
I mean, for real.
And take his co-counsel as court appointed. I did that once. I did that after Omaha, when I ended up not having to do the trial in Omaha, and I had a big trial in federal court, actually in Chicago. I was like, I need co-counsel for this case, and she's indigent and can't afford to pay another lawyer. So my co-counsel was court appointed.
Yeah. I know.
So it can be done. It's very unusual, but it can be done.
Well, I mean, look, Brad Rozzi, this guy, SP74, Brad Rozzi, I quit. I didn't quit. Well,
maybe, right.
Maybe not.
Something to it, right?
I'm
gonna quit. No, I'm not. Is more accurate.
It's exactly how I said it went. Like
but what I'm saying is, if you're saying I quit, I didn't quit, it's more like he said, I'm going to quit. And then he's like, I'm not going to quit.
Right. Well, no, I think what he did is he stayed his execution beautifully. That's what he did. I like, he wasn't letting the judge force his hand on the 19th in the way that he thought to escape that death by not filing an oral motion. You know, I mean, so by like he clearly, in order for her to have pulled him orally, he would have had to say, I'm making an oral motion withdraw. And he clearly did not say that. He's of record now.
Okay, right. And JD's asking, how is it okay to backdate a motion? And
a motion or an order?
Well, that's what I was going to explain. So there's, the judge is essentially saying, this is the order that I was writing and signed on the 19th. I just never electronically updated it. Now, right now, that's kind of happening a lot, with only like in the sense that we, the lawyers, write the orders typically, and then we submit it to the judge to sign. And when we weren't doing remote proceedings, that all happened at the exact same time. I handwrite the order, I hand it to the clerk hands it to the judge signs it, clerk stamps it, it goes in the system, I get my copy. But right now, like, we're doing remote things. So before 2 p.m., I've got to file and upload my my order for the judge to sign. So I upload it on the 21st. The judge doesn't end up signing it until like the 22nd, and then it gets back to me on the 23rd. And then it so it depends how it hits the docket. But this is very unusual in the sense that so much time passed, and she's trying to say that that's an order she signed on the 19th. Yet if it wasn't file stamped, whether it appeared on the docket or not, what matters is, when was it given to a clerk to be entered as a matter of record. And that is the date, regardless of what was signed, at least based on, and I haven't researched this fact in a while, but the last time I researched it, oral rulings don't rule the day. It's the written order, and that's the date, because can you still hear me? Because
yeah, we can hear you, but you're frozen. I don't know why you're freezing. You're closer to the Wi-Fi than I am.
I don't know, but I'll just keep talking.
Yeah, keep talking. You look super cool in that picture, though. Oh, there you
go. That it's the written order that, the clock starts running from, and everything has to go from. So typically that is what will trump, would be the file stamped when it is of record order, and not the date of the order. Maybe you should have entered it nunc pro tunc officially.
And if we've got any indie lawyers out there, and I know the one Reddit subgroup that I love and actually hang out in is Delphi Docs. And it's a great sub. And like yesterday, what I want to know, because this appears that the judge almost typed this directly into the docket.
Well, but look at the rest of it. Those are all the minute
you didn't re-email it to me, and I ended up sending it some nether world.
Here, I'm gonna request it. Hold on, I'm gonna request it. So,
but what I'm saying is, it appears to me like to be a minute order where they draft it right into the docket.
Yeah.
So that's what I'm saying. How can she say that it was entered on the 19th? What proof does she have that she entered it on the 19th? I think she's SOL, to be honest with you. This is completely a responsive. Here, log off and log back on because you're frozen.
Okay.
And I like to see your beautiful face in full action. All right, so Debbie, thank you for the $20 hollow. That's incredibly generous of you. Ashley Crum, thank you so much for the super sticker. $5 holla. JD, you came through a couple times, man. JD Driscoll, thank you much. I think that Allison just answered that question for you. And Trish, thank you so much for that $10 holla. We appreciate that so much. Let me scroll through and see if there's anything. So, y'all, there's a ton going on right now. Obviously, I went through. If you're late to the live, I read both of the main filings of today. The thumbnail of it, the Cliff's note is basically Rousy is stating that he is still of counsel, that he is just putting it on the record that he never withdrew. And I agree with them. I like it. You've got Rousy filing this last night on the 25th at about 7:50 p.m. He then files a motion. The other major motion was a motion to disqualify Judge Gull from the matter, which will go up to the chief judge, which might be Diener, who has recused himself from the case. It's a very sticky situation with what's going on right now. It really, really is. It's getting more and more nerve-wracking as we progress in terms of how this is all going to play out, because we just don't know. And then while we were on the live, Judge Gull finally enters an order relating to many, many things. Hold on, let me bring Allie back on. To many, many things, namely that she was ruling on multiple motions that were still outstanding, and that she was putting on the record that both attorneys are withdrawn as of the 19th. She dated it. She basically what they call nunc pro tunc. That's where she's going back in time and fixing an order. I mean, typically it's like we're going back to fix an order. She's like not nunc pro tunking the entire order as if it actually happened on the 19th. It's going to be sticky. What Judge Gull is doing is creating an appellate nightmare right now. That is what Judge Gull is doing. I'm telling you. Michael Dixon says, I feel like Bob could be more kind to Allison. Wow. I'm sorry you feel that way, Michael, but I adore my wife, and she can more than handle me, buddy. Trust me when I say that to you.
Such a brute.
I know. I'm so mean to you.
We're both heated, and we over the years, there's, certain ways that we both know how we're
both very passionate people, period.
Right.
Like, I don't need to explain anything to Michael Dixon. Like
Well,
I adore
yeah, you
you, and
can.
I respect the hell out of you, and I'm never trying to demean you or do any of that. Like when we talk, y'all are getting the real us. Sorry. And if you we might not be your slice of, your slice of bread here, man. I mean, maybe we're like, but you're getting our authentic selves, and we adore each other. We respect the hell out of each other. Allison's the baddest lawyer I know, and bad meaning good, not bad meaning bad. So, and I'll just leave it at that, but like when Allison, and we'll go at it. Like Allie and I are not afraid to disagree on things, and Allie can more than defend her position on anything that she wants, and has shut me down on plenty of occasions. So
All right.
don't worry about Allie. All right. Let's see. Is there anything? Am I missing any other ones? I think that's it. All right. So, babe, do you feel like you think we got everybody up to speed?
I think that we did.
All right.
I'm hoping to get my hands on the actual order to see when it was stamped.
That's what I'm saying. I don't think there is an actual order.
Well, we're about to find out.
I think she's just typing this stuff. Oh, Clee, my boy Clee. Clee. Dude, it's going down on 31st, brother. I might have to come spend the night at your house so I can make sure to get
Just
in.
so everyone else knows, apparently Clee Oliver is also attends court on this case, so they know each other from that.
Yeah, Clee is an awesome human being, Indiana guy, like huge Delphi guy. Been involved from the get, and just like beyond that, salt of the earth guy. So thank you, Clee, for joining and becoming a member. I really appreciate that, and I'm looking forward to seeing you in a few days, man. That's for certain. So I'm going to do one more quick. All right, so y'all follow me on TikTok. That's Defense Diaries Podcast. Follow me on Twitter. That's Defense_Diaries. Join our insiders group on Facebook. That's Defense Diaries Podcast. And in that, you'll find an invite to a private group, and it's called the Insiders. It's a great group. A lot of great people in there that. And
I just want to say, in the middle of all your little spiel there, that this judge's ruling is definitely going to interfere with Rousy getting the transcript and the audio if they were going to give it to him until this is resolved, because the judge has ordered him withdrawn. So for now, until this is addressed, I don't think he will be getting any more records or transcripts or anything of that nature, unless, of course.
And you just answered this question exactly. So I think that was the over. I mean, look.
I saw her question, and because of my policy, I didn't reference her, but I answered it anyway.
And we're assuming it's a her. It could be a he.
Sorry, Riha could be.
So, and
unless of course
our typical policy is if you're not a member at the very least, and or you've given us some kind of little love.
Pay for your question thingy.
For question things that we don't ask. Like I'm far more lenient with it. Allison's really.
But as you can see, I kind of addressed it without saying it, because I saw it and I noted it to be a really good question. So
thank you, Clee. I appreciate that, man.
So I mentioned it, and Desiree. I mean, there's no stopping Desiree. She's passionate about this.
I feel like. I got to come up we've got to come up with something amazing for her, because she's so generous. It's unbelievable, really. All right. So I think side question from JD. If I'm a Patreon, does it count? In my world, yes.
Well, if you have a question, then you just write, I'm a Patreon and here's my question.
Yeah. If you're a Patreon for the podcast, at 100%.
But we're always going to answer anyone that does like a
super sticker
with their question. It's always going to get answered. And then, we'll scroll through members and answer. Did Rousy file today or last night? Last night.
So about 7:50
And that little mark
PM.
means she's a member, right, babe?
Yeah, that little thing, that little S thing is a member. Okay, let me see if there's anything else. We concur with
Baldwin bring on Rousy, or is he from the judge? What does Clee mean?
So wait, what did Clee say?
Did Baldwin bring on Rousy, or is he from the judge? Oh, are they both court appointed, or was one of them?
They were both court appointed, like independently. So, like I mean, Clee, in a case like this, you cannot have one lawyer handling it. It's just too much for any one person. So when they originally got appointed, she went with two. You know, like it's going to be super interesting, Clee, on the 31st, because there's going to be two other lawyers that walk into that courtroom like, well, Brad's still saying he's still in. Like, what are we doing? And the judges will say, well, ignore Brad Rozzi. You're the lawyer. It's going to, oh my God, it's going to be, the whole thing is going to be unbelievable. I cannot wait.
Yeah, we have to figure out a way to identify, you know, Patreons, but I don't know that there is.
We don't think so, police activity. We think that was referring to a tort action that was filed probably pro se by Richard Allen to try to get him, you know, in terms of a violation of his civil rights. We don't think it was.
Here's what we're going to do. We're going to do a Patreon something either tonight or when. We're going to do it.
Okay, I think we do. You mean a Patreon exclusive live?
However is that, I don't know how it works. However, it would work with doing it for people.
Well, yeah, I create the live and then I make it private to only our Patreons, and then I give them like an access code. So we'll do it.
And it'll be just questions and answers of whatever they want on.
And y'all, it's probably because I'm going to be on Vinny from 7 till 8 Central Time, but they got me talking about Adelson. I'm going to try to swing Vinny over to Delphi. I'm going to really tell Vinny, man, look.
Yeah, I don't think it's that simple. Like he gets to do whatever he wants to talk about.
It's Vinny's show. Vinny
write those scripts out ahead of time.
Nobody tells Vinny what Vinny's going to do. You know what I mean? Like Vinny runs it. Yeah, but no, you're right, because they put together like all the little pre-rolls and stuff like that. Where
Sandy gets all the goods. It's true.
Yeah. All right. So, all right, y'all, we love you. We had a massive showing today. Thank you. I think we peaked at like almost 600. So that's amazing. Please, if you haven't subscribed to us, we promise.
Yes, we've got to figure out a way to give Patreons a special emoji. We'll figure out if there's a way
we've got some, but yeah, there's going to be the Patreon special emojis. There's going to be those that are incredibly generous, like some kind of super special emoji too. And like if you haven't subscribed, please subscribe to YouTube. This channel, we will give you great content. I'll try to be nicer to Allison because I'm I just know that I love her and I adore her and I respect her and I think she's amazing in every single way. And I'm never trying to be rude to you, honey, on purpose. So if I am, I apologize publicly to the entire world. I think that's it. All right, so y'all,
and
Patreons,
hop over to Publicly Buzzed. They're doing a live.
Yes.
Trial.
Yes, dudes, I'm sorry. What time y'all going on tonight, Steve? Publicly Buzzed. Let me give you guys the love. Steve, okay, wait. Perfect. Here we go. All right. So y'all, this is great tonight. Publicly Buzzed, one of our partners in crime and like our two of our favorite human beings, Steve and Dan, have an amazing channel. They're going to be digging into Adelson tonight. Which if you guys don't know about the Adelson case, it's crazy. Trial just started today. Obviously, Allison and I got way sidetracked because we found out that
actually we were going to cover Kohberger. Now we didn't.
I know Kohberger. There's a hearing going on in Kohberger too. It's like there's too much happening in the true crime world. I just can't keep up. So yeah, but you guys, everybody, hit that link tonight. This is going to be great. Like the Adelson trial.
Right now,
so you guys have
it's right now. They're doing it right now.
What? Right now?
Publicly Buzzed.
Oh, they are? Okay.
Yeah.
Man, I wish I could portal them. Let me think if there's a way. Can you talk for a minute while I go backstage? Just say goodbye. You love everybody.
Okay. Oh no, I'm here alone and I don't know what to do or say. All right. Well, oh yeah, I was going to say, I was like, wait, isn't Jay on right now? So the shaming of Jay is on right now covering the Adelson trial. Bob, it's Jay. I was sort of confused. I was like, wait, Publicly Buzzed is doing it right now? And now do I not mention that the shaming of Jay is doing it? But the shaming of Jay is covering that And I think that Bob's trying to figure, at least I'm pretty sure that's what the guys from Publicly Buzz is trying to say. Yes. Okay. The shaming of Jay right now. Go over, and Bob's going to try to figure out if there's a way to portal everyone over. And they are covering the Adelson. He is covering the Adelson trial right now. And I know Bob was thinking about popping on that with him. So we'll see if that's actually going to be able to happen now. And then Publicly Buzz tonight, 10 o'clock and Eastern time. And don't miss that. And I think I'm still supposed to continue to talk to you guys until Bob figures out what he's trying to figure out. So if anyone has any other question, I might just answer it so that we can help get you guys over to this Adelson stuff, because Adelson's what Bob's talking about tonight on Vinny, where he thinks that somehow he has the ability to like shift Vinny over to a new subject matter on Prime TV. Like, hey, let's go off script and talk about this other thing that happened, which I don't think is going to happen. So they're going to be talking about Adelson. And that is what the Shaming of Jay is live on his YouTube channel. That's the name of the channel, the Shaming of Jay, right now doing. It's crazy interesting from what I heard just from like this morning. And I don't know. It seemed to me like the defense's theory was like, well, this guy who happens to be the brother-in-law of the murdered victim, he was just joking with his sister about, you know, it's cheaper than getting a hitman. And why would he keep joking to so many people if he was actually going to hire a hitman? So it's like, and I heard that on some other fronts as well, where they were talking like, well, why would he, there was one other thing they said. It was like, why would he tell everybody that if he was about to kill him? And why would he talk about killing him right before he killed him? That seems stupid. So I don't know. I mean, the defense has to work around it, but I do have the orders entered today that was sent. So we've got the order today. Sorry, I'm looking at it now. Okay, wait, that's not the order. Order issued. Okay, order for judgment of court. And, well, that's interesting. So the judge dated it October 19th. Then on the bottom, it says a copy of this order was served either by mail to the address of record, deposited in the attorney's distribution box, or personally distributed to the following persons. And it's got both the defense attorneys and the state's attorney on today's date. Now, where I'm used to seeing at top, it being stamped by the court and having some electronic like indication, there is none. There is none. So this order, we just received it. It wasn't. And then there's also a motion for continuance that was sent. And that was filed today at 8 a.m. And that's by Rousy saying like, counsel for the defendant is unable to locate any specific order wherein the court scheduled the initial October 31st hearing date, nor is there any order which articulates exactly what matters were to be addressed and how much time was to be set aside. However, counsel does acknowledge that there have been discussions between the court and the lawyers regarding the 31st hearing and the possibility of the court conducting a hearing on the pending suppression motion filed. Then he goes on to say on the 18th, defendant Allen filed a motion for Frank, September 18th of 23. Frank's motion was filed October 2nd. Supplemental motion, October 3rd. Additional Frank's notice, October 14th. The court ordered defense Allen's team to cease working and prohibited counsel from engaging in preparation for the October 31st suppression hearing or any other matters. On the 19th, the court engaged in action that resulted in the court ordering the withdrawal of Baldwin from this case. Attorney Rousy remains the only active attorney of record, which we know the judge has already kind of taken that away. And for those reasons, they request that the hearing on the 31st be continued to a date and time following full and final disposition of the motion to disqualify filed October 25th, 2023. So, oh, sorry, this was filed this morning, October 26th at 8 a.m.
All right, yo.
I just let everybody know we got the order, okay?
Yeah.
And we got a motion filed this morning for a continuance that was filed at 8 a.m. saying that the court ordered on the 19th Baldwin removed and that Rousy remains the only active attorney, and asked to continue the 31st hearing until the disqualification motion is ruled upon.
Wait, who filed that motion? Rousy?
Yes, and the judge's order, it's not stamped at the top. It is signed, printed as being signed on the 19th, but the notice was given today. Notice under Rule 72D went out today.
Wow.
And there's no clerk stamp on it to say what time and date.
I mean, that sounds like a Judge Gull issue that she's gonna have to deal with. So, all right. Y'all, I'm like, if you don't know Shaming Jay, you're about to, because when we end this live, I have figured out how to portal you, magically transport you over to Jay. Check it out. Just don't do it.
Yes, it will be worth it. I promise you.
Jay's amazing. He's hilarious. He's super kind. And he's
maybe Bob or I will pop in.
Yeah, and he's a great part of our community. Thank you guys for joining us for Just Facts. We love you. Exciting day, a lot going on. We're gonna probably do more lives. We are gonna do that Patreon exclusive thing. We'll let you all know, all of our Patreons in there. And again, thanks for joining us. We out.